morning, guys. Welcome to Share Your Views. My name is Amma Mavis, and as usual, I'm your host. Now, if you like my makeup, it is by Nene Beauty Store. Nene Beauty Store is located right opposite Fraga Oil at Abeka. They do all kind of makeup. They do makeup for every occasion. They do bridal makeup as well. They sell beauty products. So if you are interested, just contact me for their numbers. Most of you are wondering why I'm in black. Nobody is dead. We are just talking about the law. Remember that on Share Your Views, we talk about anything that you can think of. Our resource person for this week is Mr. Raymond Bidema Esquire. He's here to talk about employer and employee kind of contracts. So he's going to be defining who an employer is and who an employee is. He will also be talking about breaches and remedies that are available when there's breach of contract. And finally, termination of contract. Stay tuned, you don't go anywhere. Enjoy our videos.
My name is Raymond Bidema. I'm a lawyer with Meto Nono Kote and Partners. I'm into private practice. And this afternoon, I am going to talk about employer-employee relationship, the contract that they go into, how they can terminate the contract, and what will be the available remedies for the innocent parties if there is a breach of any of the terms of the contract. So, an employee or an employer is actually any person who has a work, and so he wants someone to come and do that work. And employee is the one who offers himself for the work that is available by the employer. So, by way of definition, it's more or less of a contract between the two. It is a contractual relationship, and this relationship is governed by the Labour Act of Ghana. And so, like every contract, the basis of the contract is agreement. So one man must make an offer, and that man, normally we call him the offeror, and the other man must accept the offer, who is the offeree. So in this case, or in this sense, the employer is actually the offeror and employee is the offeree. There are other circumstances where the employee may also be what? The offeror. That is where the employee is the one who has sent the application seeking for the employer for the employment opportunity. In that instance, then, the reverse is true, where the employee becomes the offeror and then the employer becomes the offeree. And as I earlier on stated, the essence of a contract is agreement. So once there is an agreement between the parties, then it means that there is an offer with its accompanying acceptance. So one makes an offer, and when there is an acceptance from the other party, then there is a contractual relationship. Now the question is, what is a contractual relationship? It is actually an exchange of promises between an employer and employee in this regard, where the employer says, I have a job, and the employee says, I am available and I can do that job for remuneration. So the valid element of every contractual relationship is also true to employer-employee relationship, where there should be an offer made by one party with its corresponding acceptance of the other party. There should also be intention to create legal relations. This means that when there is that agreement between an employer and employee, they must be ready to be bound by the terms of that contract. And there should also be capacity to enter into the contract. When we say capacity, we are looking at the relevant knowledge of the parties. Are they capable of understanding the import of whatever agreement they are entering into? And in Ghana, when it comes to contractual relationship, the age is 21, but that is not true when it comes to contract law. We have different ages where parties can actually enter into a contract. Now, there should also be a consideration, and the consideration here most of the time is the remuneration that the employee will be getting out of the contract that he intends to offer. So when all these elements of a valid contract are present, then there is actually a relationship between employer and employee. Now, if you look at the definition given by the Labour Act, and employment is actually, they say it is employment of service. And the question now is, what is employment of service? And that is where it is a bit difficult to define because there is no definition to it. But we have to look at certain tests that over the period the courts are able to use in determining whether a person is is an employee or is a independent contractor. And we have three of that test. We have what we call the entrepreneurial test. We also have what we call the integration test and control test. Now, control test has to do with where a person is controlled by what he does, the nature, the scope, how he does that work, then we say that that person is actually employee. So for instance, if I control the way and manner X does his work, then X is my employee. And that's what we call the control test. Now there is a case, I don't want to sound too legalistic, but for the purpose of this discussion now, we want us to examine the case of Christian Walker versus Crystal Palace Football Club, where there was a breach of a contractual relationship and Walker went to court, and the court held that once the football club determines how Walker plays football, there is a coach who shows them this is your position, this is how you play it, then Walker is actually an employee of the Crystal Palace Football Club. So where a man is controlled by the way and the manner he does his work, then he is literally an employee. So that is what we call control test. So the courts over the period look at whether or not the person is controlled by the way of which he does his work. If once he is controlled, then he will be an employee. The next one is what we call the entrepreneurial test. And the entrepreneurial test is basically who actually enjoy the benefit of what the employee does. Is it the employee or the employer? Is it if A gives work to B and A is supposed to enjoy the benefit, only out of the benefit he pays B, then B is an employee of A. Right? So it's like, on whose account is B working? Is B working on his own account? If yes, then B is an independent contractor. But once B works on the account of A, he gets every money, he pays into the account of A realizes the profit and pays B, whether it is daily, monthly, weekly, whatever the terms of the contract may be, then B is literally an employee of A. Now, we have another test that the court over the period also used to determine whether one is an employee or an independent contractor, and that is what we call the integration test. And the integration test is whether the person supposed to be an employee is an integral part of the business. And when we say an integral part, then it means that you have time to come to the workplace and the time to leave. You cannot actually decide when to go. There is a defined time for you when you have to go, and there is a time where you leave. You come at 8 o'clock and you leave at 5 o'clock. There is that kind of definition. So it's not like where you have given work to someone and that person, depending on his availability, depending on his convenience, comes to work. Then in that regard, then you are an independent contractor. Now, if the one who employs you or the one who gives you the work gives you the time to come and the time to close, then in that case, the court over the period will consider you to be an employee. Now, like a contract, every employment opportunity or every employment contract gives the parties their duties and obligations. And when you come to the Labor Act, because it is the Labor Act that controls how work is done or how labor is to be given out in Ghana, it also defines in Section 8 of Labor Act and Section 9 the duties of an employee and then an employer. So the duties of an employer is in Section 8 and the duties of an employee is in Section 9. If you care to know, some of the duties of an employer is to provide the employee with work, provide him with adequate tools for which he will use to work, and to provide him with that conducive environment at which he will be able to do his work. And it is the responsibility also of the employee also to come and do the work. However, it is not the responsibility of the employee to provide himself with work. So you, the employee, whether or not there is work or not, your duty is that when it is 8 o'clock, you come to work, and 5 o'clock, you go. Whether there is work for you to do, it's immaterial. The most important is that there is actually time frame within which you have come. Whether there is work or not to do, it is the responsibility of the employer to provide you, the employee, with work to do. There are plethora of cases that state that where employee comes to work and there is no work, it is not his responsibility actually to provide himself with work to do. Now, like every contract, where there is a breach of any term of the contract, then the innocent party will have a remedy at law in court. Some of the remedies could be damages, and instances where damages may not be sufficient, then they can ask for specific performance. Now, there are instances where employer relationship may be terminated, and one of such relationship is where there is a death of one of the parties. So if an employee dies, then the contractual relationship comes to an end, because you cannot have a contract with a dead person. Also, where if it is a company who is the employer and the company enters into insolvency, then the relationship also comes to an end, because once it enters into insolvency, except where maybe there is an injection of money for it to be restructured, that company may be wound up, and if it is wound up, then the company fails to exist. And once it does not exist, then the employer relationship can come to an end. There is what we also call operation of law. That can also bring employee relationship to an end. And when we say operation of law, for instance, where there is a court judgment declaring that one party is no longer an employment of the other by the employer, then that is it. Or where, for instance, you are declared, let's say you are declared insane, or maybe there is a judgment that is preventing you from carrying yourself in the capacity of an employee of an employer, then you may also cease to become an employee of that company. There is, like every contractual relationship, it is based on voluntary agreement of the two parties. Something we call the voluntary agreement, where parties have entered into that agreement voluntarily, or like party autonomy. So they have entered into that agreement based on the fact that they have actually accepted to be parties to that agreement. They can equally also enter into the same agreement also to come out. So as do we call it mutual agreement between the parties. So I have accepted to give you certain services for which you are giving me remuneration. At a point in time, we have come into an agreement that relationship to come to an end. So it's a mutual agreement between parties to end the contract. Then the contract may also come to an end. There is another form where we call it lapse of time. When we say lapse of time, what we are literally saying is that, for instance, where you are employed for 6 months. So after your 6 month service to the company, and they don't renew your employment contract, then the employee relationship will come to an end. That we call lapse of time. So it means your employment is controlled by a time frame, and you have actually served that time frame, so you come to the end of the employer-employee relationship. Basically, that's the contract of employment.
As usual, do not forget to follow us on all our social media platforms. On Facebook, Mavis Amini. On Instagram, Ama_Gavo. On TikTok, Ama_Mavis. And on WhatsApp, 054-3077-506. Thanks for watching our videos. See you next week.